Greetings, my name is Luke Ryan and welcome to This Date in the Drug War. Today is June 25th. 13 years ago, a sharply divided United States Supreme Court found a high school principal named Deborah Morse did not violate the First Amendment rights of a high school senior named Joseph Frederick when she gave Frederick a 10-day suspension. Joining me to discuss the case is Bill Newman. Bill is the director of the Western Massachusetts office of the American Civil Liberties Union of Massachusetts, as well as the author of two books, When the War Came Home and Life on the Co-op Plan. Bill is also the host of the Bill Newman Show on WHMP and a columnist for the Daily Hampshire Gazette. Bill, thanks for joining me.
Pleasure to be here, Luke.
So before we get into the very nuanced legal principles at the heart of this decision, I was hoping you could tell viewers what are the four words that inspired an opinion from Chief Justice Roberts, two concurrences from Justices Alito and Thomas, and two dissents from Breyer and Stevens. What did Joseph Frederick decide he needed to say that gave us this Supreme Court opinion?
Right. He said these memorable words. Actually, they were written on a large sign. Bong Hits for Jesus. Now, I remember when this case first came up, and it was national news, well before it got to the Supreme Court. And I asked a number of people, what does that mean exactly? I mean, I'm old, so tell me what it means. What does Bong Hits for Jesus mean? And I never did get a clear explanation. Apparently this was not cultural or based on age problems that I was suffering from. It just doesn't make a whole lot of sense. And in fact, in the case, Joseph Frederick says, hey, I was goofing around. I really didn't have a specific goal in mind. There was this large camera crew, national camera crews were there up in Alaska in Juneau. And I thought it was a great time to get on TV and to have some fun. And well, so Bong Hits for Jesus, but I wasn't really thinking through exactly what it all meant. And what happened, of course, as you know, is that the principal, that would be Deborah Morse, says that is a message that is promoting illegal drug use for youth. Well, she wins the case on the basis that Chief Justice Roberts says, well, that's not totally implausible. It could mean that. And if she thought it meant that, and she's a principal, and there's a school involved, because you could see the sign from the school itself, well, then the school must have the right to censor that speech and discipline this student. Now, by the way, all the appeals they did go through, the internal appeals of the school system, which resulted in the suspension being reduced from 10 days to 8. I guess someone thought Bong Hits for Jesus wasn't all that serious, but it was still serious enough to give him the 8-day suspension, which was the time he had served out of school by the time the case got to the school board. So that's what happened. And you're right, it spawned all sorts of opinions from the Supreme Court. The Supreme Court, in its majority opinion, reversed the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals because the Ninth Circuit Court of Appeals had come out in favor of the First Amendment and student rights. And the Ninth Circuit, we should note, reversed the district court, federal district court, which said, nope, it's okay for the school to do this. So a lot of litigation all over Bong Hits for Jesus. And one other thing on this, by the way, the majority opinion written by Chief Justice Roberts goes out of its way, and the Chief Justice goes out of his way to say, definitely it could mean this. It could mean this. It could be promoting drug use, illegal drug use. But he goes on at great length in the opinion to talk about how horrible drugs are, and he conflates marijuana with all drugs, and it's a mission of the schools to discourage drug use. And he writes an almost Brandeisian brief on how that is an objective and an important objective of schools, to dissuade students from using drugs, and therefore the schools have the right to prohibit, as this Juneau, Alaska school system did, prohibit any kind of expression that encourages drug use. And he says that's a totally rational and a fine position for a school to have. Pedagogically, that's really important. And therefore, they can enforce their rules that say, no, you can't encourage illegal drug use. Well, I don't know. I mean, I really don't know how the Chief Justice got to this. It encourages drug use. But he says, I'm going to defer to the principal. She thinks it does, so I'm going to agree with the principal, which leads me to think the decision itself tends to lack principle.
Hmm. So in reading the opinions over again, I think I was most struck by Justice Stevens' dissent. So this is back, he's 87 years old at the time and has the benefit of being able to look back when he was in school during alcohol prohibition. And he talks a lot about the parallels he sees from his days as a student. You want to talk a little bit about that?
Well, I think that the Chief Justice loses track of what it was like to be a senior in high school and say, you know, we did things as a senior in high school that, well, looking back some years later, we could say, what were we thinking? And the answer in most of those instances was not much. And I think that the dissent clearly has it right on First Amendment grounds, has it right in terms of students, and I think has it wrong in terms of what schools should be doing and constitutionally, in my judgment, should be permitted to do in terms of suppressing student speech. There was a long discussion in this case, in both the majority opinion and in the concurrences and the dissent. And we could get to Justice Thomas's dissent, which is really mind-boggling. But that position only had one vote, which was Justice Thomas's. We should be grateful for that at least. So the decision, I think, significantly dealt with the Tinker case. And Tinker versus the Des Moines Independent School District is the case from the Vietnam War era in which the Supreme Court held that the suspension of students, the disciplining of students for wearing black armbands in support of the Christmas bombing moratorium and in opposition to the war, that the school system could not punish students for having that expression and making that expression in class during school. And the Tinker case really is a high watermark of student-free expression. And the case contains those memorable words that students do not shed their First Amendment rights at the schoolhouse gate. And that, of course, is what is at stake here in this case from Juneau, Alaska. And this court kind of glides over the issue about whether this is a school event and says, of course it's a school event, and school events are the same as being in school. So therefore, this expression can be banned and can be suppressed and can be punished. I think the case itself comes down to, we really don't like marijuana. And therefore, you know, if a kid gets in trouble for expressing himself or herself about marijuana, well, that's no big deal because all drugs are horrible. Marijuana is horrible. It's the scourge of the nation. We need to prohibit marijuana in any way we can. And that's kind of the underlying.
Do you see an underlying sense too that in addition to that, there's a almost besmirching of the name of Jesus that goes along with it too, like the conflating of drugs with Jesus becomes problematic for a pretty conservative majority of the justices?
Yeah, I think this is generational in some ways. These are older. Well, but of course the dissent is not exactly a youth brigade. So, but yeah, I think in terms of understanding what youth does and what high schools are like, I think that the majority has its own preconceptions about the evils of marijuana basically override constitutional considerations.
Now, you mentioned Tinker, and in my introduction of you, I referenced your first book with the title "When the War Comes Home." Can you talk a little bit about what our history is when we're talking about things like the Vietnam War and a war on drugs, and what the impact of a war mentality tends to have for civil liberties?
Yeah, I think if you go back, and this history is 100 years old, certainly goes back to the First World War, that when there is a war, one of the casualties is the fundamental rights that we cherish in the Bill of Rights and in our Constitution. And the governmental response often is to suppress speech, to target enemies, to put people who criticize the government in jail, to destroy their lives. And when you hear the war on, we should be really careful, because wars tend to take as a victim precious civil liberties.
And as you,
Let me add one other thing. You know, the war on crime has taken us from 350,000 people in jails and prisons in the United States to 2.3 million people in the United States behind bars, behind the razor wire today. We have 4 or 5% of the world's population and 25% of the world's prisoners. And that's because of the war on drugs, also known as the war on crime. But fundamentally with Nixon, is the war on drugs, the war on crime, it was all the same thing. And it was a matter of targeting significantly in disproportionate numbers people of color, communities of color, and destroying them. And destroying them to the extent that those politicians, led initially by Nixon, but also actually acquiesced in by Democrats along the way. Bill Clinton and his 100,000 new police officers on the streets, and the federal law, which essentially created the space for mandatory minimums and 3 strikes and you're out and all of that. Democrats are hardly blameless in all of this. But this war on drugs, this war on crimes, was a war on communities of color. And it's only been very recently that America has woken up and said, wait a second, why are we destroying brown and black communities? Why are we doing that? What's the point here? And the point is that for decades and decades and decades, the war on drugs and the war on crime has done exactly that.
now, as you look at a case like the Morse v. Frederick, and as part of a larger jurisprudence involving the war on drugs as it's waged in our public schools, and really looking at the rights that adolescents and children have or don't have. Do you see any kind of creep that historically starts with the curtailing of rights within these places where it's like Bill of Rights light that students seem to enjoy, and then becoming kind of accepted there, and then reaching out into, is there a danger, I guess is the question, as for people who, may not have kids in the school systems and they see kind of repressive, authoritarian administration, as to that getting a foothold in the law that creeps out into the wider community?
I think the answer to that fundamentally is yes. I think it works a little differently. I think the way the law segregates us from each other is to create these various institutions and places where the Bill of Rights does not apply. So, for example, the court has a body of jurisprudence now that says, sure, students do not shed their First Amendment rights at the schoolhouse gate, but Fourth Amendment rights, pretty much they do. Those school lockers belong to the school, not to the student. And as long as there's something in the student handbook that says the lockers are ours and we can search them anytime we want, students are pretty much out of luck. So there is an entire set of institutions, schools, public schools anyway, in the United States where First Amendment rights and Fourth Amendment rights are clearly, and the court says this, are not the same as they are for adults on the outside. So there's schools where those rights don't apply. There's prisons where those rights don't apply. There are series of institutions. If you work for various, if you go to work for an employer, and if you want to say something critical about the industry that you are working in, the employer can probably, it's a complicated set of court cases here, but the employer, for the most part, can prevent employees from speaking out. So you can lose your First Amendment rights because of where you work. You can, and your Fourth Amendment rights because you're in school, and lose almost all of those rights. And I don't mean to overstate that, but certainly the vast majority of rights if you're sentenced to prison. And if I'd given this a little more thought before we went on, I'm sure we could come up with another half a dozen examples where the courts and the law simply say, yes, you have those rights, but they don't apply here or here or here or here or here or here or there.
So, Bill, we're taping this about a month after the tragic murder of George Floyd, and a wave of activism that I've never seen before, and I think most people I've talked to haven't seen before.
Now it's getting generational.
As we're kind of in this, for many of us, unprecedented, uncharted waters kind of experience, I know that part of your job with the radio show is you bring in a lot of people and you're talking to them and you're reading constantly to not only be conversant with guests, but just to do your columns. Who out there right now would you say we would all benefit from sitting down and making time to regularly absorb the messages that are being communicated? Are there writers? Are there speakers? Are there people that you just think aren't getting the megaphone that their wisdom perhaps warrants?
Well, I just saw a brilliant movie, 13th. I don't know if you've seen it. And it, of course, is a discussion, a presentation, essentially about the exception embodied within the 13th Amendment. The 13th Amendment is the amendment to the Constitution, the post-Civil War amendment that prohibited slavery in the United States, prohibited one human being from being in bondage to another. And embedded within the 13th Amendment is an exception. And the exception is for persons who have been convicted of a crime. And 13th shows the historical line that connects the exception to, in the 13th Amendment in the mid-19th century, to Jim Crow, and from Jim Crow and the segregation that was a part and parcel of life in the United States, significantly, but certainly not exclusively in the South, to the new Jim Crow, which is Michelle Alexander's title of her book, which the new Jim Crow being 2.3 million people in the United States behind the razor wire today, disproportionately people who are Black and brown. So I think the answer to your question would be, if I could create a megaphone and say everyone in the United States has to listen to these two people, I would pick at least two of the people who are featured in that film. One is Michelle Alexander, and the other is Brian Stevenson, who, of course, is the human rights attorney and human rights activist, founder of the Equal Justice Initiative in Montgomery, Alabama. They are brilliant, and if we had to take our cues from people who really understand how racism perverts the promise of America, I would want to hear more from them.
Bill, thank you so much for making time in your busy schedule to talk with me today. I do hope as the project moves forward that we'll get you back on. It is always a treat to be in your company. So thank you again.
Thank you, Luke. Really appreciate it.
Okay.